Hi, I'm attorney Morgan Lay with Mel Legal, PLLC, here to talk to you today about vacating prior convictions in Maryland. I know it's been a long time since I've made a video. I started my own firm about a year ago. I'm happy to be back, and I'm happy to share with you that a few weeks ago I was able to assist a very deserving client in vacating a 20-year-old distribution drug charge. A recent decision by the Supreme Court of Maryland expands the circumstances where people with criminal convictions can ask the court to modify their sentences, including striking the conviction from their criminal record altogether. The recent case of Harry Davis Jr. versus State of Maryland broadens the landscape for the way Maryland courts view ineffective assistance of counsel claims related to their sentence modifications. This decision could impact many people who were never properly advised about their post-sentencing options and who suffer collateral consequences from their conviction long after they have paid their debt to society. So let's break down what happened in this case, what the court decided, and what it means for Marylanders or someone with a Maryland conviction looking for a second chance. This case was about a man who had been convicted in 2013 of murder and other very serious crimes. He was sentenced to 72 years in prison. After sentencing, Mr. Davis's attorney failed to consult with him about his right to ask the judge for a sentence reduction. Further, his attorney failed to file a motion for modification of sentence within 90 days after the sentencing, which would have given Mr. Davis up to 5 years to ask the court to modify the sentence in some way. Years later, Mr. Davis filed a petition for post-conviction relief. He argued that his lawyer's failure to consult with him about the modification option amounted to ineffective assistance of counsel, violating his constitutional rights. The Supreme Court of Maryland agreed. So what did the court actually decide? So the Supreme Court of Maryland ruled in favor of Mr. Davis, holding that a defendant can claim ineffective assistance of counsel if their lawyer fails to consult with them about filing a motion for modification of sentence, even if the defendant didn't specifically ask for one. In other words, if your lawyer didn't talk to you about your right to ask for a sentence reduction or modification within the 90-day window after sentencing, that might be enough to reopen your case to allow the motion to be filed. This also clears the way for people to ask the court to strike their convictions by granting them a probation before judgment and ultimately expunging the records. This decision overturns earlier cases, specifically cases like Adams or State versus Adams and Rich versus State, that required defendants to prove that they asked their lawyer to file the motion in order to claim ineffective assistance. Now the court says the focus should be on whether the lawyer was reasonable in failing to consult with their client, not on whether the defendant made a request. So why is this case a big deal? And why am I creating a video about it? Well, you could get your criminal record vacated entirely or your sentence reduced. Previously, many people lost the opportunity to ask for a sentence modification simply because their attorney never brought it up. They didn't know they had the right to file one. They couldn't prove that they had asked their lawyer to file one. And now, under Davis, the burden shifts from what the defendant requested to what the attorney should have done. If your attorney didn't talk to you at all about filing a modification, and you can show that you would have reasonably wanted one, the court may consider that ineffective assistance of counsel, allowing a belated motion on a motion for modification or reduction of sentence. So what do you have to show in order to get this type of relief? So according to the ruling, you have to show two things. First, that your lawyer didn't consult with you about filing a motion for modification of sentence, and that the failure was unreasonable under the circumstances. Two, you were harmed by that failure, meaning there's a reasonable chance that if your lawyer had consulted you, you would have filed the motion. This is based on the legal standard from a U.S. Supreme Court case, Strickland versus Washington, which Maryland courts must follow in ineffective assistance claims. So what does this mean for you? If you or someone you know was convicted and sentenced in Maryland and never got the chance to ask for a sentence reduction, including striking the conviction altogether, this ruling could help. You may be able to file a quorum nobis or post-conviction petition arguing that your attorney failed to advise you about your rights. If successful, the court could allow you to file a belated motion for modification, even if the original 90-day deadline has long passed. This could apply even if you never asked your lawyer to file the motion. Your lawyer didn't meet with you after sentencing. Your conviction happened years ago. And so what can't this do? This decision doesn't guarantee a sentence reduction. It just gives people a second chance to have their case reviewed by the court if their attorney failed to properly advise them. It also doesn't apply to every case automatically. You need to prove the facts, such as the lack of communication with your lawyer, and explain how you were affected. So the takeaway here is that Harry Davis Jr. versus State of Maryland is a meaningful win for fairness in the criminal justice system. It recognizes that people shouldn't lose their right to request a reduction of sentence just because their attorney failed to have a basic conversation with them about it. If you think this ruling might apply to your case or a loved one's case, talk to an experienced lawyer about filing for this type of relief. This case is a reminder that sometimes the law changes, and with it, new opportunities for justice can emerge. Thank you for your time. I hope you enjoyed this video. Again, I am Morgan Lay with Mel Legal, PLLC. I'm licensed in Washington, D.C. and Maryland. Like this video and subscribe to my YouTube channel for more informational videos just like this one. Thank you, and I'll catch you next time.